Good evening. You are live here with Courtside with Carmen B. No lawman today, unfortunately. Lawman is actually he's on a sabbatical, dealing with some health issues, and we wish and pray for him a fast and speedy recovery so that he can come back and debate with me on the issues as we discuss them here courtside. As you know, Courtside is an educational and an informational program. We are here to provide information and to answer the questions of the public as it relates to the criminal justice system and as it relates to social justice and other issues. Now, this weekend, there are going to be numerous celebrations of Juneteenth. Juneteenth is a celebration that relates to the signing of the Emancipation Proclamation um, back in 1863. And you will hear people say that that is what freed the slaves. The Emancipation Proclamation actually only freed those who were enslaved in the states that were rebelling against the Union. But there are going to be celebrations and remembrances regarding the Juneteenth holiday. And this is, I believe, the second year where it's been celebrated as an actual federal holiday. But it was celebrated by African American people and descendants of slaves for many, many years prior to this federal recognition by our government. So, in the local Sacramento area, there is a Juneteenth Freedom Festival that is happening on June 18th, starting at 10 a.m. at the Cesar Chavez Plaza, which is located in downtown Sacramento. It's across the street from what used to be the old City Hall. There is also a celebration of Juneteenth that is occurring on Sunday, June 19th, and that is happening at Robert Brookins Park, which is approximately um, one block from Norwood. It's one of the local parks, and so they are having a holiday rejoice festival there, June 19th, at starting at 11 a.m. There is also a Juneteenth block party that is on June 18th from 4 p.m. to 8 p.m., and that is located at 3229 Martin Luther King Jr. Boulevard in Sacramento. And there is also on uh, June 18th from 12 p.m. to 6 p.m. at Southside Park. It is the Juneteenth Celebration of Freedom pop up shop, and that is on the 18th. Those are just some of the local Juneteenth events that are going, should you choose to attend them, to celebrate and recognize the holiday in the way that you see best fit. Comment from Devinder Shah Harper, a wonderful tradition and celebration. And I would agree. I would think that one of the best Juneteenth celebrations, and I would say it was more of a recognition than a celebration, occurred here in Sacramento. And what they had was in one of the state buildings, they actually had um, items of memorabilia from slavery, um, because it's a holiday that brings about mixed emotions, because it reminds us that there was a time when our country did not see us did not recognize us as citizens, and didn't really see us as human beings. And we have to realize that that still plays a part in our society today. Now, we're going to spend a substantial portion of today's show answering questions from viewers and from people who have previously emailed in with questions relating to criminal law. So if you have a question, please feel free to post it in the chat. I have a number of questions that people have emailed in that I will be stating the question and then providing an answer to that question. But don't be shy about posting in the chat if you have a question. You don't have to identify yourself. You don't have to indicate that you're asking the question specifically for yourself. You can ask the question as if you're asking it generally or the usual for a friend. Now, one of the questions that someone emailed in was that I have a case that is pending, but they have no evidence against me. They only have someone's word saying that I did something. Isn't it true that they have to have something more than hearsay? Well, hearsay relates specifically to a statement that is made outside of court. It's not a sworn statement, and it's not something that someone witnessed directly. And I think that is confusing for a lot of people. So, for example, if I were to say, I saw the blue car hit the red car, that is not a statement of hearsay. That is something that I actually observed and would be allowed to testify about. Now, if I told Tracy I saw the blue car hit the red car, and then Tracy wanted to testify about that, and she herself had not witnessed it, that would be an example of hearsay. Tracy didn't witness what she's testifying about. She's only stating something that I told her occurred. It is evidence. Testimony is evidence. If the witness who is testifying saw or heard something that they have personal knowledge about, and they can testify about that, and that evidence is given the same weight as any other evidence. And that is why you can have a case that involves one person's word versus another person's word as to what transpired. And the jury, hearing that case and hearing that evidence, has to make a decision as to who they believe in terms of what factually happened. I tell people all the time, there's no magical halo that comes over the witness's head to let them to let the jury know, oh, this is the person who is telling the truth about what happened. What they have to do is apply a series of factors, and they're kind of the same factors that you would apply in everyday life to determine whether or not someone is being honest with you. But is it possible that someone could be lying, but the jury believes him? Certainly. And that would be an unfortunate situation, but we know that that happens and that can happen. So, to answer that question, basically, can a person be convicted on the testimony of just a single witness? And the answer to that is yes, if the jury believes what that witness has said and weighing that along with whatever other evidence, if any, is produced. So it could be that the only evidence there is that witness's statement. For example, you have husband and you have wife. Wife calls the police and says, husband struck me. Husband says, no, I did not. The jury would hear her testimony about what happened and his testimony about what happened and decide what they believed. If they believed her, they convict him. If they believe him, they acquit him. So hopefully that answered your question. Perhaps Lawman is commenting in on the chat. Is it a national holiday that we have off? A viewer called in to ask. Actually, I guess that is my assistant posting that. It is a national holiday that should be recognized. Um, but I do know that there are um, some agencies that are not recognizing or not um, giving that Monday off, which is normally what happens when a holiday falls on the weekend, is that usually that following Monday is then recognized as the holiday. Another question that we've received from another number of viewers and that we've actually dealt with in our practice is my cousin is charged with a gun enhancement, but there was no gun found. How can they do this? Again, that kind of relates back to the whole issue of testimony. So let's say there is a alleged victim who says that they were robbed at gunpoint. And they say the person who robbed me pointed a gun at me, and that person was wearing a black sweater and blue jeans, and they had on purple tennis shoes, and they ran that way. And law enforcement responds, and a few blocks away, they find someone who appears to match that description, and they bring the victim over to do what's known as a field show up with that person. And the victim says, yes, that's the person who robbed me at gunpoint. The officers search the person and they don't find a gun. In that instance, can they charge that person with the robbery and the gun enhancement? They can, based on the victim's description of what happened. Now, you may be thinking, well, if there was no gun found, how can they charge that enhancement? And it is because the witness, i.e., the victim to the crime, stated that a gun was used, that they observed with their own two eyes that a gun was pointed at them and property was taken from them. The mere fact that the gun wasn't found doesn't mean that there wasn't a gun that was utilized. It actually could have been that the person, threw the gun away or disposed of it or hid it in some fashion before they were contacted by law enforcement. It also could be that law enforcement has actually stopped and arrested the wrong person and that that person has been misidentified by the victim. It also could be that the victim didn't actually see a gun, that it was some other object, but that the victim was so afraid that they thought it was a gun. In all three of those instances, the district attorney's office could charge a firearm enhancement, and it would be up to um, the district attorney to have to prove beyond a reasonable doubt that there was a firearm that was used. And as part of the defense strategy, to attack the fact that there was no gun, that the victim was frightened, and that can be shown through the cross examination of the victim. Did you actually, was the gun placed against you? Did you actually ever feel the gun? Whether or not it was nighttime, such that it could have been some other item, but because of the fear, the victim thought that it was a gun. But the short answer to that question is that even when a gun is not found, if there is evidence that a gun was used, and testimony being a form of evidence, they could charge um, that gun enhancement. And again, we want to avoid those gun enhancements because those gun enhancements carry huge amounts of time, way more time than the actual crime itself. We have a question from Mary Ann. What is the difference between racial profiling and criminal profiling? Well, sometimes there may not be a difference, but racial profiling is where um, the officer is coming up with a set of factors of which race is the major factor that he or she is using in contacting uh, individuals, whereas criminal profiling is supposed to be based more on the fact of criminal specific criminal characteristics um, that the officer is looking for. The problem is those two things can cross over. If the officer is patrolling in a neighborhood that is predominantly African American, you're going to see that some of those factors intercept. But one of the things that we see with racial profiling is that you get people being stopped who aren't engaged in criminal activity at all. And that is one of the major um, factors that you need in order to legally stop and detain someone is a reasonable, articulable suspicion that they are engaged in criminal behavior. And that is not a hunch, but something that you can actually state fact wise as to why you believed that that particular person was engaged in criminal activity. And it has to be reasonable. One of the other questions that we have is how can they charge multiple people with possession of one gun? And I think we may have answered this question before in one of our other shows, but we have no problem answering it again. It is because there are two types of possession, there is actual possession and there is constructive possession. Actual possession is where you have the item on you um, or in an item that is under uh, your complete control. The constructive possession is where the item is not on you, it is not next to you, but you have the ability to control the area where that item is located. So, for example, if I had, let's say, an prohibited weapon, such as an AK 47 assault rifle, um, and I had that item in the trunk of my car, right?